Proceed.
Your Honor, I have reviewed the criminal report affidavit. I find it to be quite weak with the allegations concerning second-degree murder. As the court can see, it is clear by the affidavit itself that witnesses there at the scene had indicated that certainly the individual that was the initial aggressor was the alleged victim in this matter. I think that it is clear based upon reading the affidavit that this was a theater. It was dark.
How would I know it's dark? Is that an assumption you're asking me to make?
No, Your Honor, I'm not, but the movie had started, and there's
Where does it say the movie started?
It does
Just
not.
so we're only, because I can only go by the four corners of the instrument, so let's stick to that.
I will, Your Honor. You're in a theater. Clearly, it indicates that the aggressor was the alleged victim, and the allegation there is that the victim threw a bag of popcorn. I think what's important is that the interview of Mr. Reeves indicates that, number one, the alleged victim attacked him, struck him with an object, which resulted in the gunfire. So I think that certainly the facts and circumstances alleged in the affidavit are extremely weak for second-degree murder.
State, as to PC.
Judge, I would submit to the court that there is probable cause for second-degree murder based upon the facts and the circumstances and based upon Detective Proctor, along with Detective Harris and Detective Aaron Smith's investigation into this homicide.
Well, I'm only considering the four corners of the instrument. Do you have any response to the allegations that the throwing of the popcorn removes this from second-degree murder?
No, I don't, Judge. The throwing of the popcorn, there's no indication in here other than the defendant saying that he was struck. All of the eyewitnesses that were interviewed by the Pasco County Sheriff's Office indicate they never saw the victim strike, threaten, or hit Mr. Reeves in this case.
If I could just briefly have that, what started the incident may have been the bag of popcorn according to the affidavit, but what's important here is the officer's interview of Mr. Reeves, which clearly indicate that he was attacked, he was hit in the face with an unknown object. At that point in time, he has every right to defend himself concerning that particular object. And so I think, again, that they had failed to allege the necessary facts to show a second-degree murder.
The court finds in reviewing 782.04 subsection 3, with regard to premeditated, the second-degree murder, it's a, when perpetrated by any act eminently dangerous to another, I guess that would be pulling a gun, and evidencing a depraved mind regardless of human life. And the only description I have is he was struck in the face by an unknown object, not by a hard object, not that he was knocked around, just struck in the face by an unknown object. And regardless of human life, pulling a gun when hit in the face with some unknown object. And the additional information in here is popcorn. It may or may not have been popcorn, but an unknown object doesn't equal taking out a gun and firing it at somebody's chest. In addition, that certainly would be to affect the death. The court is finding that there is more than sufficient probable cause of second-degree murder. Now let's proceed. Before we do to the ties, are we okay with it off?
They're trying to see if the court remains.
Okay. Proceed.
Your Honor, my client is 71 years of age. He has been married for 46 years. He has two children, Jennifer, who was born in 1973, and Matthew, who was born in 1976. He has one grandchild. He attends Bible study at his church on a regular basis. He does have some ailments. He has arthritis on both hands, bursitis in his shoulder, hypertension, high cholesterol, and he also is in need of a continuous positive airway pressure machine because he has very low levels of oxygen in his blood. I can tell the court that he was born on August 31st of 1942 in Jacksonville, Florida. He moved to Tampa as a small child, and he attended...
Could we focus on the criteria that is established in Rule 3.131, please?
And, Your Honor, I am. I think his ties to the community is coming about here. He actually served in the Navy for a period of years and also served in the reserves. He started to work for the Tampa Police Department in 1966. He is married to his wife, Vivian, who he married in 1967. and they moved to Lutz in 1968. He retired, Your Honor, and after retirement from the police force...
When?
He retired from the police force, Your Honor, in 2003 and moved to Brooksville, Florida in 2005. Again, he has his two children here in this particular community.
Which community? Pasco?
In the Pasco and Brooksville community. When he retired, and excuse me, Your Honor, he retired actually in 1993 from the Tampa Police Department. He retired as a captain in the tactical division. In fact, he was responsible for co-founding the tactical response team for Tampa Police Department. He was a commander for 16 to 17 years, was on the selective enforcement unit, was a homicide detective, was a property crimes detective, and taught various courses at the Tampa Police Academy. After his retirement in 1993, Your Honor, he served as the Director of Security for Busch Entertainment Corporation, which is Busch Gardens, where he obtained various certifications in security. And as I indicated to you, Your Honor, he currently attends church at First Baptist Church. I've got various, this entire room just about is filled with friends and family and colleagues. I've got numerous retired police officers that are here to talk about his great character.
That's not relevant.
Well, I realize that, but I've got individuals to talk about his great character as well as his ties to the community and the fact that he has no propensity whatsoever for violence. I've got numerous witnesses that would come before Your Honor and testify that if this court were to set a bond, that there is absolutely no issue whatsoever that he would come to every court appearance and face these particular charges. Likewise, for...
I'm sorry, you want people to tell me that he will come?
Well, Your Honor, in their opinion, there is no threat of him not coming. They will also tell you that for practically the majority of his life, he has been a law-abiding individual with no prior criminal history whatsoever. He's an individual, in fact, in his law enforcement capacity, that he has been actually protecting the people of his community from individuals that do commit crime. At the time of this particular incident, and I think the prosecution would agree, there was no attempt to flee whatsoever, cooperated fully with law enforcement from beginning to end. So his ties to the community are great, Your Honor, and I believe that his danger to the community is non-existent.
Could we clarify, he does reside in Hernando County, correct?
Yes, Brooksville.
And how long has he been at his current address that's listed on the PC?
Since 2005, I believe, Your Honor.
Anything else you want to share with the court as to 3.131 before I hear from the state?
No, Your Honor.
It's all set up and everything is set up, so we can switch over to court.
Okay. We can move to courtroom A if everybody would like. It's the only way you're going to get video. And it's an indulgence, but out of fairness, I think we can do that. I am going to, while anybody who's interested in the Reeves case moves over there, I am going to start with some of the other advisories. If they didn't fix the mic, so we still have the feedback. I can't even do those. All right, we'll just move over to courtroom A as quickly as we can.